number 135, matter of Mancini versus the Office of Children and Family Services. Good afternoon, Counsel.
Good afternoon, Your Honor. May it please the Court, my name is Amina Carrick. I'm here on behalf of the appellant, Mr. Mancini. I would like to reserve 2 minutes for rebuttal.
You may.
Thank you. This Court has followed the constitutional truism that judicial will should consider legislative command. When 15.3v was enacted in 1970, the legislative command was to create a section that would protect and address a certain class of injured workers. This class of injured workers was not...
We're just looking at the plain language. So if one paragraph says, the additional compensation we set up here is determined in accordance with this other paragraph, don't we just read the other paragraph and follow what it says?
And when this statute was enacted, Your Honor, in 1970, this reference was in place. This Section 15.3 was never amended throughout the years. To this day, it stays the same. And
isn't the legislature presumed to know exactly what was there in V when it amended W?
And that's exactly my point, Your Honor. It was. And at the time that it was enacted, the statutory caps were not present in V.
So how do you get
W,
around that
excuse me.
referential language?
I'm sorry, Your Honor?
How do you get around the referential language that says, look at W, in order to affect the purpose of V to address this particular subsection of injured people?
In 3 ways, Your Honor. First, we look at the legislative intent in 1970 when it made that reference to W.
Well, why do we do that if the language is clear? Are you suggesting there's some ambiguity in this language that says go look at this other paragraph to understand what the additional compensation is under this paragraph? Why are we doing that?
Why are we looking at the legislative intent in 1970?
Isn't the language clear on its face?
It is, Your Honor, and it was clear. The intent is clear. The whole of the statute 15.3v is clear on its face, and it has a durational limitation. The very plain...
Well, but is that a durational limitation? I mean, the limitation in W has to do with number of weeks, right? And what you're calling a durational limitation in V has, it doesn't have anything to do with how many weeks or how long, because if you're injured when you're 20 versus if you're injured when you're 59, the duration is going to be very different. So why isn't that Social Security cap just sort of an end cap, and why can't that work with the week caps in W?
Yes, Your Honor. If we were to look at the 37-year-plus history of the application of Section 15.3W to Section 15.3v, it was never applied to consider any durational limitations of 15.3W or any other parameters of 15.3W except for
Was there a durational limit in W before they added this?
No, there was not, Your Honor.
So how could they consider a durational limit in W before they amended it? After they amended it, they did, right?
Exactly, and it was not another limiting factor that was contemplated by the legislature in 1970.
But again, going back to, you presume the legislature knew about V's cross-reference when they amended W. The intent was to import that durational limitation into V.
Well, Your Honor, my position is that the legislature not only knew as to V's reference to W, but also knew as to the 37-year history of the applicability of that reference.
But they were changing that. They were changing the reference, so whatever V referred to now is different, but they knew V made the cross-reference. You're just reading kind of the amendment out, I think.
Well, to that, Your Honor, if the legislature's intent in 2007 was to apply these broad statutory limitations that it implemented in 15.3W, and I think it's important for this court to understand.
Well, I think there is some legislative history that indicates that part of the intent was to create some parity between schedule, permanent partial disabilities, and non-schedule PPDs.
Exactly.
So the way you're reading it is doing just the opposite. It's working the disparity back in.
No, Your Honor. 15.3v is meant to address a very small class of injured workers. It very rarely ever comes up. It has different, the road an injured worker that seeks benefits under 15.3v and the road that an injured worker that seeks benefits under 15.3w are very different. In order to even be eligible for 15.3v benefits, an injured worker must have sustained a 50% or greater loss of use of their body member. To that, they have to prove to the court that upon their participation in a board-approved rehabilitation program, that the only sole cause as to their loss of earning power is that impairment as to their body member. They are not afforded the same considerations that an injured worker who receives benefits pursuant to 15.3w is, and those additional considerations are...
I may very well be misunderstanding how it works, but my understanding was that W, those are the only benefits they get, whereas a V, you get a scheduled award, and then you get the V benefits in addition to that. Is that accurate?
That is accurate, Your Honor.
So why would you get no durational limits in what is an additional benefit to a scheduled award, whereas in W, which is your only award, you have those limitations?
Because, Your Honor, this is the additional limitations or the additional benefits are meant to aid or to supplement the loss of use that very small subset of injured workers have, that schedule loss of use determinations, which really is, if Your Honor looks, and I'm sure the court has in our appendix, sets out a number of weeks that are the maximum number of weeks that an individual can receive. So
Am I misunderstanding that the V benefits come after the termination of the Schedule A, B, and C, D benefits? You're not getting two sets at the same time. You're getting the ones in W first, and then you're getting the V benefits.
that's correct, Your Honor. You would get the schedule loss
There's no
of use
point where you're getting
benefit.
both at the same time.
That's correct, Your Honor. And so after the expenditure of that schedule loss of use, the claimant has very strict requirements that they have to prove that they're even eligible for the V benefits. A claimant that is eligible for 15.3w benefits can take into consideration their age, can take into consideration their education, can take into consideration their training or lack thereof. And a true and accurate reading of 15.3w, none of those are taken into consideration. The only
I have
thing
a question that sort of relates to this, and I don't think it was directly addressed by either party, and maybe it, but there also is a safety net that was created in 2007 in Section 35 of the Workers' Compensation Law for extreme hardship. And do we know if that applies to V claimants as well as W claimants?
that I believe that may apply to both, Your Honor, but that's a section of the law that we don't see come up very often, as is Section 15.3v. And to that point, I
So
think
you may consider it harsh, which I think is really what you're arguing, this cap. But it is the legislative choice, so we're back to the plain language. But even if we were to look at the legislative history, as Judge Stein has already pointed out, but much of those amendments are to keep down costs. So again, even though it's a harsh result, it appears to be what the legislature intended.
I don't agree with that, Your Honor. The legislature could not have intended that after their 2007 amendment to Section 15.3w, the board was going to go back and change and contradictorily apply 15.3w to 15.3v. And to do so, and as they have done so, would be contrary to very eligibility of 15.3v benefits.
Thank you, counsel. Counsel?
Good afternoon. I'm Edward Obertebessing, attorney with the New York State Insurance Fund on behalf of the State Fund and its the State Agency Office of Children and Family Services. The respondents asked this court to find that the additional compensation benefits provided for under Section 15.3v of the Workers' Comp Law are subject to the durational limits that are set forth in 15.3w. The language of 15.3v specifically notes, as already has been observed, that the additional compensation awarded under that subdivision shall be determined in accordance with paragraph W of Section 15.3. 15.3w is where the durational limits or the caps exist in the law.
So you wouldn't read the prior language that's still there, because they never rescinded it, about, until you retire. You don't read that as a durational limit.
No, and I think that's been addressed. It doesn't create an entitlement to benefits. It doesn't say the claimant shall be entitled or that these benefits shall continue. The statutory language says that the benefits shall cease when the claimant reaches old age Social Security age, which the courts have interpreted as age 62. In matter of Ramroot, this court had an opportunity to look at the statutory language of 15.3v. And indicated in that decision that the court would not put its imprimatur on a compensation award in contravention of the statutory mandate. In matter of LaCroix, this court noted that the board can't contravene the plain language of the statutory provisions of the workers' comp law.
Well, let me ask you why I can't read the statute exactly the opposite way that you're reading it, in the following way. Section W says all compensation payable under this paragraph shall not exceed, and that has a list of items. Paragraph V says additional compensation shall be paid under V, notwithstanding any other provision of the subdivision. It then goes on to say that the additional compensation shall be determined as paragraph W provides, but why can't I read this that there are two different streams of compensation, one that is provided under V, one that is provided under W, and all that the limitation language that you're relying on in W says is that the compensation payable under this paragraph, W, won't exceed the limits?
Well, the cross-reference has been mentioned previously. 15.3v specifically says that the additional compensation set forth in 15.3v shall be determined in accordance with paragraph W.
Compensation that's how the compensation in V is determined, but that doesn't mean it's payable under W.
Except that 15.3w provides for the calculation of both the amount and the duration. The language is already there and has been there. In all cases of permanent partial disability, this is from paragraph W.
But except that perhaps the durational requirement is limited by the language I read you, all compensation payable under this paragraph. That is, can I read that clause to restrict the durational requirement to paragraph W?
Well, I think we get back to that next sentence that says such additional compensation shall. Shall is a mandatory word. It shall be determined in accordance with paragraph W, which contains now, since 2007, durational limits.
What does compensation refer to?
Well, compensation refers to two things, the amount of benefits and how long you'll get them for. In the schedule loss of use, that's a dollar amount times the number of weeks. 15.3w also says it's a dollar amount, 66 2/3 of the difference between the average weekly wage and the loss of wage earner capacity or wage earner capacity thereafter. And it refers to a duration. It's payable during the continuance of the permanent partial disability. That's where the language ended until 2007 when they added the durational limits. So now the caps apply. The legislative history of 15.3v was pretty clear. The intention of the statutory change in 1970 was to put a certain subset of scheduled loss of use recipients on par with claimants who are receiving permanent partial disability benefits. On par means equal or comparable. To accept the argument advanced here by the claimant would treat this claimant dramatically better than a similarly situated permanently partially disabled claimant. He was found to have a 37.5% loss of wage earning capacity. That equals 275 weeks. The claimant's argument to continue these benefits through age 62 would result in this claimant receiving 804 weeks, more than 10 years in excess of what a similarly situated permanently partially disabled claimant would receive. That's hardly on par. Respondents would ask this court to affirm the appellate division decision and to find that the benefits payable under section 15.3v are subject to the durational limits of 15.3w. Thank you.
Thank you, counsel. Counsel? Hold your
sorry.
tongue.
Go ahead.
Anxious.
Good afternoon. May it please the court. Patrick Woods representing the Workers' Compensation Board. I think I'll start by addressing Judge Stein's question with respect to the safety net and Workers' Compensation Law 35.3. The answer is That question has never reached the board, about whether at the end of a V award, you could then seek to have your classification changed. But I do think since you've raised it, I do think it's important to recognize what the legislature did in that provision. First, it showed that if it wants to put in language that changes something in terms of continuing benefits in a way that's different from every other benefit of permanent partial disability, it knew how to do it. And two, the way that it chose to do it was not by giving lifetime benefits for a permanent partial disability award. What happens under 35.3 is that at the end of your W award and potentially your V award, you would, if you can demonstrate extreme hardship, you can petition to be reclassified. You were classified out of being permanently partially disabled and into being permanently totally disabled. And I think that accords with the legislative intent that is throughout the 2007 amendments. Two themes, and one big one that this court recognized in Rayner was cost savings to the insurance companies, and that was the trade-off for a number of other
How many
benefits.
cases like Mr. Mancini's are there?
A very small number a year, Judge. I don't have the precise number, but it's like
Roughly,
single
I mean,
digits. a
Single
year.
digits.
It's not a very large number of cases, which is part of the reason why the issue didn't get here before and why we don't know whether a V award could then lead to a 35.3 award. Although, interestingly enough, to follow up on Judge Wilson's observation, the language in 35.3 about payable under is the same language that exists in W. So this court's decision here might affect that. Obviously, the board doesn't have a position on that because it hasn't come in front of it yet. But to point out that it dovetails with the legislative history and legislative intent is that there's two statements of intent in the legislative history here. There's the one in 2007, which talked expressly about creating parity between those who receive schedule awards and those who receive non-schedule awards, and resolved that question by doing away with lifetime benefits for those who received the non-schedule awards, and the earlier 1970, which also talked about parity but addressed it in a different way. The legislature is free to choose how it wants to address those things.
Let me ask just one question. The application of W, durational limits, does that render any part of V meaningless?
No, it doesn't, Judge. You can read them entirely in harmony.
You'd say there's no parts that are rendered meaningless as a result of the amendment?
No. And in fact, I would encourage if you look at the language of V, and as this court interpreted it in Ramroop, the participation in rehabilitation program requirement and with identical language, presumably the age cap, these are requirements for continued payment. You can read the statute very harmoniously by saying such additional compensation is determined in W. At that sentence, you go look at W, and you see amount of money for number of, not to exceed a certain number of weeks. Then you come back, and for the durational requirement, for the age cap, it says, and shall cease on the date. In other words, the payments that you would get under W that are set duration and amount, then cease if you hit that age. There's no part that's rendered out, that's read out, because you certainly could have individuals who would receive the full amount of benefits and those who would hit the age cap. They're read, they can and should be read together.
So let me ask a variant on what I asked previously. If you think of these, again, as two separate streams of payment, you may not agree with that, but just hypothetically think of them that way, as separately set out. Is there a way to read the durational requirements in W to be applied separately to the two streams? That is, you first get your initial set of awards. That can't run past the durational cap. Then if you are eligible for the V award, you get the V award, and that starts at clock zero, but is again subject to the caps in W. Is there a way to read the statute that way?
I'm not sure I'm following that, Judge, because the initial award, in order to qualify for V, is not under W.
Right, it's a separate payment. So first I get my W award, that runs, it's capped as in the statute. I could then receive a V award, but that's capped also as the statute. You just start running the clock over again.
No, and I think that's where I'm disagreeing, Judge. In order to get a V award, you have to have an award under 15.3A through D.
Yes.
So you're not going to have a situation where you have a W award that then you've run out the clock on, and then you get a V award.
And how about an A, B, or C, D, or D award that's subject to the caps in W? Could you get that first for, let's say, your 300 weeks, and then, subject to the same cap, get the V award?
A, B, C, and D awards aren't subject to the caps in W. They're a set number of weeks set out in the statute. Those two provisions are two different ways that the legislature decided to deal with different kinds of injuries. They don't cross-pollinate, so to speak. If I could just make one very
Yes, of
brief
course,
point
sir.
with regard to harshness. To the extent that we want to read this as harsh, I think that's not a good way to look at it. The petitioner here is still receiving 275 additional weeks of benefits in addition to the schedule loss of use award, and doing better than a similarly situated W person.
Thank you,
Thank you.
Counsel. Ms. Carrick?
Yes, Your Honor, just to follow up to what my colleague here indicated, that the petitioner here would be doing better than a similar situated individual who's receiving benefits pursuant to 15W, I wholeheartedly disagree. The appellant here had to take a very different road in order to even be eligible for these benefits. The appellant here did not have the potential benefit of having his age, his education, his other medical comorbidities to be taken into account when addressing his loss of wage earning capacity. The only thing that the appellant could rely on is that his loss of use of his body member was the sole reason for his wage impairment. And in following up with the definition of compensation, Your Honor, Workers' Compensation Law Section 2 defines compensation as the money allowance payable to an employee or his dependents as provided for in this chapter, and includes funeral benefits provided therein.
Doesn't the money allowance also take into consideration how long you get that money allowance? In other words, the total of the money allowance depends on how many weeks you get it, right?
Your Honor, I would disagree, and again, I would look to the 37-year in this particular instance, and in reading these two very distinct and separate parts of the statute meant to address very distinct and separate injured workers. I would read that differently. I would also note that the reference in Section 15.3v to 15.3w does not come at the end. It comes in the middle. It indicates that such additional compensation shall be determined in accordance with paragraph W of this subdivision, and then it goes on to say within 15.3w itself, and shall cease on the date disabled employee receives or is entitled to receive old age insurance benefits. Therefore, the plain reading of this section of the statute indicates that the durational limitation contained therein is the proper durational limitation that should be implemented. Thank you.
Thank you, Counsel.